had it on the other side, so I don't grab it and read it. Hey, did you get you got a new one?
Yeah.
Oh.
Everyone's good? Everyone's good? Ready? Okay, we're going to get this panel going just so that we can stay on schedule. So it's wonderful to be here, and the conversation thus far has been engaging, and I've certainly learned an awful lot, and I'm looking forward to learning an awful lot from the panelists we have before us now. So let me introduce each one very briefly. More information about them is obviously in the material. Mario Bonds is an associate professor of law at the University of Miami School of Law. He teaches criminal law, constitutional law, and race and the law. I actually first met Mario when he was a Hastie Fellow, and back then it was perfectly clear to me that he was going to be a brilliant scholar, and indeed he is. And one of the parts of his work that I really admire is that he takes doctrine quite seriously. Mitsu and I always punt the doctrinal questions, so it's nice to see that Mario is picking them up in a very productive way. Angela Onwuachi-Willig is Associate Professor of Law at the University of Iowa College of Law. She just moved there. She teaches family law, employment discrimination, and critical race theory. I met Angela when she was a third-year student, I believe, at the University of Michigan School of Law. And here, too, it's wonderful to see how much she has flourished. Not only does she do work in the context of employment discrimination, but she's also been thinking very critically and carefully about interraciality and how that might shape how we think about anti-racism more generally. Gowri Ramachandran is a professor of law at Southwestern School of Law. She teaches employment law and constitutional law. I met Gowri, too, as a student. Gowri was the editor of the Yale Law Journal, and Miso and I were publishing a piece, and the feedback that she gave us was simply superb, so much so, in fact, that we said, we've got to get her to work with us in some context. And so when Joel invited us to submit a chapter in employment discrimination law stories, we turned to Gowri and said, will you help us do this? And happily, she said yes, and the piece was all the better for it. Emily Houh is a professor of law at the University of Cincinnati School of Law. She teaches contracts, critical race theory, and commercial law, among other courses. I met Emily when she was a law clerk, I think, at the same conference that I met Angela. And an important part of her project is to think about the ways in which critical race theory and economics can actually be combined to attend to problems of discrimination. I think that's a very productive scholarly agenda indeed, perhaps for self-interested reasons. So I'm delighted to have her here on this panel. William Cobbett is a professor of law at Louisiana State University School of Law. I did not know Bill when he was a student. I don't think he knew me when I was a student, but that I don't think should be disqualifying. He teaches employment law, employment discrimination, labor law, among other courses, and writes primarily in the area of labor and employment law. So each of the speakers, again, will speak for no more than 7 minutes, and I'll be a fascist about this so that we can open up the floor for conversations. Why don't we start with Mario?
Thank you very much. I'm extremely pleased to be here. Devon failed to mention that the first time I met him was at a conference where I gave him a ride to the airport, That's and right. On the way I got horribly lost. So I don't know how you came to think I was, bright, but I appreciate you. You're not judging me. How it is that I think I come to sit here is that last year, my colleague, my good friend and fellow law traveler, Angela Onwuachi-Willig, and I wrote an article about looking at proxy discrimination under Title VII, and we said to ourselves, this shouldn't be a one-time thing. We should try to become a poor man's Me Too in Devon and really put out a string of articles. And so our second article that we decided was going to be, we were fairly outraged, both of us, by the shift in the National Basketball Association dress code, especially in that we felt that the new policy was really an attempt to regulate identity, and mostly black male identity, out of a league mostly comprised of black men. And so we were thinking about, as Devon talks about the doctrine, a doctrine or an architecture to begin to discuss our concern and enter the Jesperson case. And why we gravitated toward Jesperson? Because we really did think that what we wanted to talk about was this notion of identity stereotyping, and that perhaps then by looking at least to the Jesperson languages, which says that the sort of Price-Waterhouse line of cases is not dead, we really could, if we wanted to, construct the legal world premised upon a claim under Title VII for stereotyping, even though that court wasn't willing to do it in the end for that plaintiff. We found illuminating and helpful. We were especially interested, mostly because as we started to look at the history of the racial appearance code cases, starting for many people with the Rogers case, what we found is courts just not willing to confront the notion that there were any traits that were expressive of racial identity, whether it be your appearance, your hair, tribal piercing, whatever. There's nothing, it seemed, for the court that could be a corollary or a correlate to race or to some sort of identity expression within the racial, of a racial category. And so, sort of up against that backdrop, we started imagining, okay, so how can we come up with a doctrinal framework that heretofore the court hasn't been willing to entertain, and how can we steep ourselves in a literature that helps us build a case for why this is necessary? And so the literature was perfectly easy to find, and it's so great because many of you are in this room and you've provided the foundation for where we start. And we talk about, in the piece, Dean Bartlett as sort of foundational in asking questions about the workplace being gendered and raced based upon social norms. We talk about Barbara Flagg, who is here, and her really sort of, in our minds, revolutionary work about using Title VII based on the notion that you should be able to challenge transparently white decision making. And then, of course, our idols, Devon and Me Too, who gave us a whole new lexicon with identity performance and working identity in particular, and specific to this piece, their article, The Fifth Black Woman, which actually asked the question of can we have or could we have a racial stereotyping cause of action under Title VII. I don't know that you answered your own question, by the way, in that article, but here we are.
That's the notion that we punted.
Nonetheless, and so we wanted to begin to add to that literature by joining in and suggesting, well, how is it that we would imagine we could use the doctrine to explore this belief that we believe employers really do attempt to regulate identity through appearance codes. And what we found was the actual architecture from the cases, from the Price-Waterhouse, Jesperson, and really Desert Palace, where we talk about being able to use mixed motive standards rather than the sort of traditional McDonnell-Douglas framework. What we should be asking with appearance codes is whether the protected group membership served as some sort of motivating factor for the challenged decision. So when we talk about the MBA policy, which actually Angela talks about in the paper, but not in this talk, what we talk about is what is it that's guiding this? Yes, it might be that they just want a more professional look for the MBA, but really we feel like part of what they're trying to get away from is these stereotypical notions of black male identity or urban identity or thug identity, which could be raced as black. And so we wanted to ask the question, well, could we set up the doctrine, walk through it, and looking at the case law and deciding how we would look into these appearance codes or grooming standards from the notion of are they at least motivated in part by negative stereotypes or reliance on negative stereotypes. And we run up into a brick wall. And the brick wall we ran into really was the anti-essentialist critique. And the anti-essentialist critique, which we mostly sort of locate in the paper and the critique of Richard Ford, has to do with the fact that there are many scholars for whom they don't like the direct trait to race or identity group association. And Rich Ford in particular finds that he's not moved or impressed by these notions of cultural essences because he believes that to adopt such encourages members of the minority group to define themselves in terms of the stereotype. And so, but it's not just Rich Ford. His book Racial Critique predominantly undertakes to explain why he has problems, but the work of lots of people in this room who we respect and like the work have problems with this notion of the direct trait to race or identity group association. In particular, we've been reading. We just finished looking at Catherine Fisk's new article dealing with privacy autonomy as a way around the equal protection model, because in part she's not comfortable with the essentialism involved in the rate to trace critique. Gowri, who's on this very panel, and two of your pieces, and most recently in your exposition of why liberty or freedom from dress might be a better way to go, also cites anti-essentialism as a way, reason for moving away from that critique. And we won't name too many more because I got 2 minutes, so I have to hurry up. And Kim Eureka, who I ran down as she was walking into the building this morning, and said, "Oh my God, I love your work on trait discrimination as race discrimination, because you actually give a very nuanced, complicated set of factors that a court could look to decide whether a trait is in some way synonymous or correlative for identity group protection." And so our own contribution was to say, fine, we have a model, we have this mixed motive model in structure, but how would we begin to imagine what the complaint or claim looks like? And we came up with two theories or paradigms for how you might imagine the claim. And one is the claim we call the individualist paradigm, in which we are okay with, in some ways, you being able to make an individual claim that you express your identity through some appearance or expressive trait. If for Miss Rogers, if for Mr. Eatman in the Second Circuit, their hair, their dreadlocks really is symbolic of their race or culture to them, we suggest that there ought to be an availability for them to advance that claim, subject to some sort of, I guess we would say, delimiting by the court. And here we actually turn to Kim Urako's work and her suggestion that what you have to do is ask questions about how the traits are perceived, what are the prevalence of the traits, but to actually ask if there's some subsection of the community or identity group for which this is actually I guess, an identity-associated trait. Now, of course, it's not simple, it's not easy, but our theory is even if you allow it, you're not somehow allowing the rest of the group to be conscripted in to this notion of that's how they express their identity. All black people do not express their identity through their hair. I don't even have any hair, so you know that can't be true. But we don't want to eliminate the individual complaint. We think that what most scholars are calling for, however, additionally, or instead of, seems to be more of what is a perspectival or a paradigm or theory, where what we really do is defocus or remove the focus on the employee and just ask what was on the employer's mind when they advanced the policy. Was sort of gender, racial stereotyping, or negative stereotypes associated to gender and race part of what motivated the policy? And that way, we don't care if it's a white employee, an Asian employee, it's we only care that the employee is somehow disadvantaged. And so we sort of set that out as an alternative, and I know I'm over time, so I'll just really sum up by saying it. So we put these two things out. We sort of gleaned some support for relying a little bit on essentialism from Kenji Yoshino's recent work on saying sometimes you just have to privilege certain norms and say the positives might be better than the negatives for essentialism. And Kwame Anthony Apaya's work also talking about normative stereotyping in a positive way. And then we talk about how we would get past the sort of prima facie issues that have been limiting the availability of the claims in the previous cases. But I have to stop before I get yelled at by Devon. But I look forward to talking to you.
Great, thanks.
Me next? Okay. First, I want to thank Catherine and Me Too for inviting me to the conference, and I want to thank the students at the Duke Journal of Gender Law and Policy for obviously a great job done on organizing the symposium. The other thing, I'm going to embarrass you, Devon, since Devon met so many of us when we were students, and he wouldn't say it himself, but it obviously says a lot about the influence that he's had on so many young scholars and the good job he's done of mentoring young scholars and young legal scholars.
I'm going red,
so.
but the challenge.
As Mario and I considered new standards for evaluating dress and appearance codes, in particular by using the NBA dress code to suggest a mixed motive type of analysis, I decided to explore one recurring theme throughout the NBA dress code debate: the way in which comments by black players and commentators who supported the code and viewed it as racially discriminatory were seen as and used as powerful tools to directly refute the claims of those blacks who viewed the code as bound up in race or racially motivated. In particular, I wanted to explore this theme as a means of examining the evidentiary power between what I call black against black testimony in employment discrimination cases. And as I see it, the theme adds an important layer to our understanding about how witness testimony by minorities against other minorities is evaluated in the decision-making process. In particular, the way in which identity performance may also be a part of the testimony itself, and how the failure of juries and courts to recognize or acknowledge such performance can result in this evidence receiving more weight than it should. So in this talk, I'll use the debate about the NBA dress code as a case study to identify 3 categories of behavior that I call volunteer discrimination, accommodating, distancing, and resigned modeling. And in so doing, I contend that these 3 categories must become an integral part of fact finders' evaluations of testimony from pro-defendant minority witnesses in race discrimination cases. And I'll define those categories later. But first, I'll just briefly state, what does the code state? The code basically says that players, when they're in the business of doing work for the league, they have to wear business casual attire. And they define that by wearing long-sleeve shirt with nice slacks and nice shoes. But they also directly prohibit players from wearing certain kinds of clothing that tends to be linked to hip-hop culture, a culture that's been negatively racialized and negatively stereotyped as black. And in particular, it prohibits the wearing of jerseys or sports apparel, chains, pendants, medallions, and headgear of any kind. And the players themselves are split on this issue of whether it's racially motivated. And so I won't really deal with that now, but I'll deal with these 3 different categories. And the question I raise in this talk is, can a person, quote unquote, volunteer for race discrimination by choosing to remain complicit with structures of group subordination? And I contend yes. And the 3 categories I focus on in making this contention build upon the work of many people, again, in this room, Professors Carbado and Gowri, Professors Flagg, Bartlett, Houh, Ramachandran, many, many people, Yoshino, Yurako. And each of these people in their own way have essentially pointed out how working within an organization necessarily requires negotiating and performing identity, and that for racial minorities, such performance requires extra work in order to counter negative stereotypes. And finally, these categories build on a point that Professor Barnes and I made in our first article, that racial identity performance by blacks who wish to be included in the mainstream carries with it also the need to distance oneself from persons who can challenge one's identity performance. In fact, I argue that what's occurred in response to the NBA dress code by some black players and leaders fits within these 3 different categories of behavior. Now, what are these categories? Well, the first behavior is accommodating, which I define as actors that simply assume or accept the merit behind definitions of culturally acceptable appearance standards without any challenge. And actors who accommodate encourage others to conform their behavior to socially acceptable appearance standards regardless of their racialized meanings or in spite of them in order to advance in the work world. And one good example is the policy that Hampton Business School, historically black university, has for its students in the program. The students in the program are not allowed to wear dreadlocks, braids, or any unusual hairstyle. So here we have a historically black university defining these ethnic hairstyles as inappropriate. And of course, the idea here is that students at Hampton need to learn and abide by appearance standards of a predominantly white corporate world. Right, so that when they get into the corporate America, the transition will be easier. The second behavior I examine is distancing, which is, in a way, an extension of the act of accommodating, in that it requires those who fit into the mold, those who accommodate to some extent, to distance themselves from blacks who are outside of the norm. So blacks who engage in distancing may or may not accept the merit of what are culturally defined as acceptable standards, but they recognize the need to adhere to such standards to succeed, especially in a way that publicly displays their difference from those outside the norm. Right. And one other good example would be, there have been studies that have shown the way in which first and second generation black Americans who have been in a way in the United States deemed the model black minority work to distinguish themselves from black Americans, legacies of slavery, by either emphasizing their accents or emphasizing their cultural background. And the third and final behavior I examine is a behavior called resigned modeling, in which the actors may reject cultural mainstream definitions of socially acceptable performance or at least recognize the way in which these norms may be racialized, but they resign themselves to conformity for the sake of modeling the behavior to those who may follow them, young people who would look up to them. So much of what Anne was talking about with the students at UNLV, that many of us have that reaction, not because we accept those standards, but because we know the importance of those standards in succeeding in the world. And again, these actors don't buy into culturally acceptable norms as defined by society, but they, like their accommodating and distancing counterparts, volunteer themselves for such discrimination because they see no way around performing their identity in a way that adheres to these norms. And in the NBA dress code, we see these comments come through players like Charles Barkley, who says, yes, I think it's racist, I think it's racially motivated, but I don't care, because the kid on the street who's looking up to the basketball players and doesn't know that he can't wear the gold chain to the interview will benefit from this new dress code, right? So again, oh, I have plenty of time. Speaking fast for no reason. Okay, so again, the rationale for those who engage in resigned modeling is not that the racial sentiments behind the new dress policy are appropriate, but rather that the young children who look up to the people in these positions have to abide by these culturally acceptable norms. And therefore, the players have an obligation to these children to model conforming behavior. All right. So in terms of looking at evidence, in Title VII employment cases, courts and juries routinely cite to and rely upon contradicting testimony by Black witnesses against Black plaintiffs as extremely strong or conclusive evidence that discredits the plaintiff's claim of race discrimination at trial. So for example, in upholding a district court's trial finding that a Black plaintiff was not a victim of discrimination, the Fifth Circuit noted the following about the persuasiveness of a testimony by the defendant's Black witness, Early Harris Jr. It said, as to the fact of discrimination, the district court was particularly impressed with the testimony of Early Harris Jr., a Black employee of the defendant, who testified that he had personally experienced no discrimination and had witnessed no discrimination against other Black employees at Tallahassee Motors because of race. And the question I ask, or rather the claim that I make, is not that such testimony by Harris is irrelevant or is not convincing or should not be convincing, but that we should consider how identity performance, in particular the pressures that Blacks have to perform their identity in a way that's racially palatable, either through accommodating, distancing, or resigned modeling, how these things may be motivating the testimony of the contradicting witness and may actually be a part of that witness's performance, him or herself. So I'm there.
Thanks.
Hi, thanks. Devon, I hate to do this, but I need to remind you that I was actually also a student when we met.
I wasn't sure.
So it's 4 out of 5.
Emily, I may have been as well, I'm not sure.
Well, I want to thank also Mitu and Devon and Catherine and Duke and the students. This has been a great conversation, and I'm just happy to be a part of it. I'm actually a critical race and contracts person, and the reason I was probably invited to be on this panel is because in my other work, and continuing still, I have been working on this, contractual good faith claim, anti-discrimination claim that actually attempts to operationalize the work that Mitu and Devon have done on working identity. But I'm not going to talk about that today because I'm tired of talking about that because I've been doing it for a long time and I need a break from it. And what I'm going to do today is I sat here and I had this very theoretical talk prepared, and I'm going to talk about it, but I'm cutting it substantially because I want to tell a story because I've been so inspired by so many of the things that people have said today. And the story, you already know that I have tattoos, so I might as well, tell you another story about myself. This is a story about my first job out of law school, which was a clerkship. And in the chambers that I was in, it was all female, and it was all women of color. Astounding. And you might have thought that this was a little slice of heaven, and in some ways it was. It was really a paradise in a lot of ways, and a nice transition to kind of to go into the, less a world that didn't look like that. But what was really interesting about it was that there were so many interesting things going on in terms of intraracial and gender performance and politics. First of all, one thing that I noted when I got there was that, law clerks gossip, right? I mean, we all talk to each other, and you learn soon sort of like the culture of everybody's chambers. And what I learned about the way that other law clerks perceived our chambers, which was very disturbing to me, was that, we were the good-looking chambers. We were the well-dressed chambers, and that was very disturbing to me. My judge was a black female judge, and all the other women in chambers were also African-American. And the other thing was that my judge would often tell me before going into court, put on some lipstick, or that lipstick is too dark, you look like, what my mom used to say, you look like you're going to a funeral. Or those shoes, terrible. I have really small feet, so it was hard to find shoes so small, and luckily I found a place now. But I mean, these kinds of things. And then another comment I once heard my judge, or she would tell lawyers coming in, or visitors to chambers, that she would say was, she would introduce me when I was the senior law clerk and say, this is the brains of the operation. But she wouldn't say this about her other law clerks. And I was just like, what is going on here? And I understood this as all a very complicated thing, and so I kind of want to take up Barbara Flagg's call to sort of think more complexly and problematize, because there's so many interesting things going on here. And I also want to take up something that Adrian said about sort of clothing performance as act of rebellion. Because I really feel that one thing that was very important to my judge was looking impeccable as an act, a response to a very palpable oppression on the court, at that particular bench, which was very white male, and on which she had a reputation that I think was very raced and very gendered in a negative way. It made me also really think about how white and male and heterosexual workplace norms and cultures impact the way that people of color and women interact with one another in the workplace, and how our workplace identities are constituted and being performed with vis-a-vis one another. Because I think it's just something that we haven't really much touched upon. And that brings me to sort of the theory part of my paper, which is I want to talk about Claire Jean Kim's theory of racial triangulation, because it's something that hasn't, unfortunately, found its way into sort of critical race theory literature. It's been footnoted a little bit, and Bob Chang is doing some work on it, I know. But it comes out of, Claire Jean Kim is a political science and Asian American studies scholar at UC Irvine. And her famous essay, The Racial Triangulation of Asian Americans, first appeared in the journal Politics and Society back in 1999, and it just really hasn't been picked up by crit people. And what her triangulation theory responds to is this sort of mantra of getting beyond the black-white racial paradigm, right? How do we get beyond the black-white racial paradigm? And what does it mean to go beyond the black-white racial paradigm? And she kind of identifies two dominant approaches that are very well articulated also in the critical race theory literature, about, that are both basically Omi and Wanet's social constructionist, like race trajectory type of paradigm, and then the racial hierarchy approach, with whites at the top, blacks at the bottom, and everyone else in between. And Kim's critique of both of these models in very short, is that they don't adequately take into account that racialization processes are mutually constitutive. And, so basically, social construction theory kind of theorizes race as, blacks' racial experience is contingent on the history of slavery, Asians on the history of exclusion, and Native Americans on the history of genocide, Mexicans and Latinos on the history of occupation and occupation. And she says that these are important ways to theorize about race, but that they're mutually constitutive. And so she proposes a theory of race that's in turn based on Stephen Jay Gould's notion of racial geometry. And she envisions what she calls a field of racial positions, wherein, she says, Asian Pacific Americans are racially triangulated vis-a-vis white and black in a field. And the architects of this field range from business elites to politicians to producers and transmitters of popular culture. and that we are positioned in a triangular shape because of sort of two linked processes that create an axis, two axes, one of sort of inferior superior and the other of insider foreigner. And she says that these axes are constructed by two processes, one called racial valorization and the other civic ostracism. And then she used some really, really compelling and persuasive historical examples, for example, the importation of Chinese labor, the model minority myth of Asian Americans, affirmative action, and to kind of explain these theories. And today, we don't really talk about these things explicitly anymore in racial terms, but we talk about it in terms of culture, right? And that's what we've also been talking about today. And she says that culture has become code for the unspeakable in the contemporary era. And I think that, now we talk about workplace culture norms, we talk about collegiality and civility, and all of these things are kind of code for race and gender discrimination along these axes. And one thing that I'm interested in, I could say a lot more, many pages, but we don't have much time, and I'm more interested in what you have to say about these things. But one thing that, is sort of missing from her triangulation theory and her sort of axes of racialization is sort of the gender component and some of the things we've been talking about here today. And so one thing that I've been thinking about is thinking not only sort of on a plane, a scale of two-dimensional plane, but sort of multidimensional, where you also have an axis of something called, as Kim Uraka was saying this morning, gender conformity or assimilation, or as Laura Morgan Roberts and Daryl Roberts were speaking of sort of gender profiling as sort of a third axis that we can talk about. Because the thing that I think that is important about Kim's work and why we should try to import it into the legal discourse is that it gives us a sort of concrete way to theorize about race in a much more complicated way that much more accurately kind of depicts what happens. And so my claim is that this should be considered a form of discrimination, and that I've kind of lost it. I can't believe it. Well, that we should think about how to sort of import this model into the anti-discrimination discourse, essentially. So it's very scattered and random, but.
Thank you. Gowri.
So, like everyone else, I want to thank Me Too and Catherine for inviting me here, and Me Too and Devon for letting me co-author that piece with them, and for all kinds of other help and mentorship that they've provided me over the last few years. It's really invaluable. Essentially, what I want to talk about today is an article that, unfortunately, I didn't circulate, but it's coming out soon in Maryland Law Review, which is an article in which I argue that we should have, not that we do have as a doctrinal matter, but we should have a freedom of dress, like the freedom of speech we have. So this is sort of like an answer to Ryan's question. I know you asked earlier, what makes dress any different from the Fourth Amendment, and except there's a little twist on that. I'm trying to explain what makes dress really, really important, like the Fourth Amendment, right? Because it's not as if maybe in the workplace we can think that dress and the Fourth Amendment are being treated sort of similarly in that both can be regulated by most employers. But outside the workplace, there's actually quite an assault on freedom of dress. Children in public schools in America and in other parts of the world are having their dress regulated in ways that are racialized and sexualized and all of these things, but also in ways that are just about getting children to conform, like school uniforms in public schools and that sort of thing. And the reason I think that it's important to do this is that someone mentioned that part of how we got Title VII was through a long history of civil rights activism. I really don't think that we're going to move too much further doctrinally on this until people accept the fact and affirm the fact and think about the idea that dress and makeup and hair and tattoos and piercings and all these forms of self-presentation are really, really important. They're not trivial, and a lot of people have said that today, but we really need to fill in the details and provide that normative argument for why this activity matters at all, because there are a lot of people in the world who don't think that it matters or have a knee-jerk reaction which they say that it doesn't matter, as Jenny described, even though they are responding as if it matters quite a bit. So that's sort of the main purpose of this article. And so the first step in the argument is to sort of discount the idea that dress is just a type of speech. We can just think about it as important because it's like a subcategory of First Amendment activity. There are litigants who have brought cases in which they argue that their self-presentation is a type of First Amendment activity, and sometimes they're successful and sometimes they're not, but usually not, because dress is considered some kind of adjunct to speech, less important than speech. And I think that dress is a little bit different from speech, or it's unique among types of speech and art, because it's a kind of expression that occurs on our physical bodies, using our physical bodies. So not just tattoos and haircuts, but even our clothes. They touch our bodies. We feel differently, and we walk differently, and we even think differently when we're wearing tight jeans than when we're wearing sweatpants. It makes a huge difference, right? There's a huge sort of physical aspect to this, which I think legally makes it very distinct from speech, because I think employers and schools and other private institutions have far less excuse for telling someone what to do with their bodies, and far less of a plausible claim. I think that what people within those institutions are doing with their bodies is so easily imputable to the institution as a whole. So that's sort of the main thing that I think distinguishes dress, not only from other types of expression that we might think of as First Amendment expression, but also from all the performances and traits and things that people do that are racially salient and sexually salient in all of this. We've seen a sort of worry that there's a slippery slope, that if we protect these kinds of behaviors, then employers won't be able to tell anyone what they can do ever. People will be able to harass their coworkers. People will be able to smoke at work because maybe Asian American people smoke more than other people. All kinds of activities will be protected, not just at work, but elsewhere as well, if we consider them to be really important. And I think that dress can be distinguished and treated as unique apart from these other activities because of its use of the physical body in order to communicate these messages. So in a way, I think it's actually the sort of almost ultimate form or ultimate realization of that adage that the personal is political. It's very, very personal. It's happening on the border between me and my body and the rest of the world, and it's visible, and that makes it political. And I think focusing on the body, it might raise this question of why we would include something like the way someone dresses or the makeup that they put on within this right if we're so concerned with the body. Why wouldn't we only care about tattoos and piercings and haircuts and things that are actual manipulations and alterations of what we sort of traditionally think of as the body? And I think the reason we can expand outwards from what we've maybe traditionally thought of as our biological bodies is that it's informed by all of the important work that everyone has been doing, for over a decade, starting with Dean Bartlett's work. Our clothes really are so important to ourselves in the modern world that it's almost like they're parts of our bodies. They physically touch us, and they just communicate to the rest of the world who we are as individuals and who we are as members of a community or people who want to distance themselves from a community or whatever it is. So that's sort of what I try to do in the article. But the main thing I want to sort of say today, since we don't have much time, is that I do think it's really important for us to make these kind of, whether we use rights rhetoric or whatever rhetoric we use, we need to really talk about why these activities are important, not just because of their racial salience or their gender salience, because I really think, we're not going to get that far if people don't start don't stop thinking of all these identity performative behaviors as just trivial and things that don't matter. So yeah, I think that's about it. I'll stop there.
Thank you, Gowri.
Well, first of all, I'd also like to thank Catherine and me too for including me in this star-studded group, and I'd also like to thank a very talented and organized group of student editors of the journal for all you've done on this. My essay is kind of a strange little essay, I'll admit that to begin with, on appearance-based discrimination. Dean Bartlett posed the question at the end of the first session today, how about general appearance-based discrimination? And I emailed Ryan and said, that's what I'm really thinking about writing about. I hope that fits within the parameters of the conference, because that's what I'd been thinking about. And strangely in conjunction with reverse discrimination, which is what I was really researching at the time and planning to write this past summer. So I hope I can bring those together and show how actually, as I began thinking about appearance-based discrimination, it worked quite well for me to try to tie those two together in thinking about discrimination law more largely. So let me try to defend this little thing and explain what I was doing here. I started out talking about appearance-based discrimination, physical appearance-based discrimination in society at large and, of course, in the employment context. I don't think I have to make a very strong case for that to persuade people that it occurs, and it occurs pervasively in our society and in the employment context. So I begin this little essay by supposing that there is a conference much like this one in the future celebrating the 25th anniversary of the federal legislation prohibiting appearance-based discrimination in employment. And I play through that and then say, of course, you won't be at that conference, I won't be at that conference. I'm not sure that anybody will ever attend such a conference because I don't think such a law will be passed. Now, I know that it's possible. I know that Santa Cruz has done it. I know that Madison, Wisconsin has done it. I know that Washington, D.C. in a manner has done that. But I would predict, and I'm not very good at predictions, but I would predict that we will never have a federal law prohibiting discrimination based on physical appearance, generally speaking. And my guess is most people would agree with me on that. So I'm pretty much at a stopping point in the essay. If I made a prediction, I think everybody would agree with it, but I don't stop at that point. Because what I wanted to do is go on and say, well, why not? Why shouldn't we do that in employment discrimination law? And that leads me into, as I say, this kind of came at a point when I had been researching and working on issues of reverse discrimination. And it led me to think about this, that for those of us who consider ourselves supporters of employment discrimination law and we try to make it do everything that we think it should do and can do, that we're often disappointed with our body of employment discrimination law, and in particular with our theories and our proof structures. And I've been thinking about the issue of the Americans with Disabilities Act. We become very frustrated and say, why won't it work? Why can't it do what it's supposed to do? So I think many of us become frustrated and say, and we've talked about this issue earlier today, do we ask employment discrimination law to do too much? And if we do, are there other places we can go in our own law to work on some of these issues? So I looked at it from that side as far as the appearance-based discrimination. From the other side, as I thought about reverse discrimination, you often hear a lot of criticism of employment discrimination law from, I could say opponents, but people who have frustrations with it. And they say, why don't you just apply it consistently? Isn't it employment discrimination law? Why don't the same principles apply in all cases? Why would you make distinctions in reverse discrimination cases and traditional discrimination cases? So I see it coming from both directions. And thinking about appearance discrimination law, I pose this question and have for years now when I start teaching the employment discrimination course. I ask my students to think about employment discrimination law broadly before we begin talking about McDonnell Douglas and mixed motives and all of that. And I say, do you think appearance discrimination occurs in society? Most of them do. They think it's very pervasive. I ask them, do they think it's wrong? And many say, well, maybe, or it's not exactly right. It shouldn't happen in employment, maybe depending on the job. And then I ask, well, why doesn't the law address it? And that begins taking us somewhere, I hope, as we think about, because most of them don't believe there will be such a law. And so why not? And I guess three main points I want to make. They're very obvious points, but I think that sometimes the public loses sight of them. Maybe sometimes we do. I lose sight of them. But employment discrimination law is limited. We know that. What it can do in regulating discrimination and changing society, there are some limitations to that because we have other goals that we're also trying to accomplish. And so there is a mediation and a compromise being struck. BFOQ is a wonderful example of how employment discrimination law does that. Employment discrimination law is not monolithic. It's not a single set of principles that applies across age and disability and race and sex. We have different principles, different theories, different doctrines that apply differently in different areas. And finally, and this is the thing I have to remind myself of, is obviously not all discrimination law is equally strong. We have stronger, relatively strong race and sex discrimination law, weaker age discrimination law, and still weaker yet disability discrimination law. All obvious points, but I guess the reason I make those, and I'll close very quickly with this, but it helps me to think about appearance-based discrimination when I say, surely it's wrong, surely the law should be able to do something about that, but I don't think it can, and I don't think it will, because I think our employment discrimination law does much of what can be done, but it does have its limitations. And when I get frustrated with the Americans with Disabilities Act, I have to look back and say, comparing that with appearance, there are a lot of common characteristics, particularly that when you define the class, it is not a cohesive, well-defined class. So even though it's a weak law, and perhaps the ADA, and doesn't accomplish all of what we'd like, it's quite a feat, really, to pass a law and to accomplish some things with it. So as we think about discrimination law, appearance gives me pause to think about some of the limitations, and also sometimes to look back at discrimination law and say, maybe it doesn't do exactly what I would hope, but it does a pretty good job. And sometimes I come to appreciate the body of discrimination law more fully when I look at issues like this.
Well, thank you very much. We have some time for questions. I'll just ask a couple, which I won't ask the panel to actually respond to, so they can get your questions as well. So just a few quick questions on the table. One is, for Bill, whether or not you think that if indeed a law were to pass that would prohibit appearance discrimination, that would actually reduce the amount of gender and race discrimination that we see in the workplace. To put it slightly differently, whether there's some kind of relationship between appearance discrimination and race and gender discrimination. Gowri, I'm wondering whether you would accept either of these, that there should be an absolute right to dress and an absolute right to performance, whether you would embrace either of those. Emily, I'm interested in thinking about the way in which you invited us to contemplate a racial world that is multiracial and what that might mean. Concretely, if we think about a number of employment contexts within which the dynamic is not white on non-white, but non-white on non-white, how do you think that context shapes, if at all, how we should think about questions of performance? Angela, I wonder what your starting point is for thinking about a case in which two witnesses about to give testimony, one white, one black. What's your starting point with respect to thinking about both of those witnesses? Is it that the black person ought to be treated with more suspicion because he's staking out a position that suggests that there is no discrimination? I mean, what's your starting point for thinking about those two? And I'm wondering, Maria, as well, if you could say something more about the community standard that you have in mind with respect to rendering a cognizable a person's expression of trait. But let's take some questions from the floor. Yeah.
I'm interested in exploring, and this touches on something that each of you said in some way, interested in exploring how trait-based discrimination is a proxy for status-based discrimination, because what we have here is Title VII clearly says because of race, because of sex, and we have these other categories like sexual orientation or gender identity, transgendered status, or appearance that don't have that kind of protection. And so when we start to do things like reject essentialism, we begin to reject a meaningful ground upon which to build a Title VII style claim for because of sexual orientation at all. So I'm wondering if the idea of rejecting essentialism, especially this goes to Mario and Angela, is really about trying to reach that trait-based discrimination as proxy for status.
No, I think that is exactly what we're trying to say. We're trying to say that they're, in addition to their recognizing individual rights, individual claims, that this is a group-based claim. This is based on perspectives that employers may have, that people who are decision makers may have in general about it. So if people perceive dreadlocks as something that's Black, right? And that's attached to all these negative stereotypes that are attached to Black people, and therefore they perceive people with dreadlocks as being lazy or dirty or whatever all those things are, that is a broad-based claim, even if someone who's wearing dreadlocks is not making any kind of racial statement with it.
Also, this seems to really come into play, I think, when you talk about the transgendered cases, where in order to sort of get relief, you have to style them as a sex claim, right? At least it seems that that's mostly what you have to do, rather than actually a question, because otherwise it's just you're talking about the group transgendered, or perhaps even, I don't think it's sexuality, much more sexual of a gender expression issue, but that we do it as sex because that's within the architecture that we can understand, that's the status that's protected, rather than moving outside to groups for which there are no protection. And in some ways, I think your question is maybe a question about, are we sometimes asking race and sex to do too much and to protect more than they can, because that's what we have in the in the statute. And I would say maybe. The part of the problem is, Angela and I mean, we really do believe part of what motivates some of these policies are these negative stereotypical understandings of identity. And if that's part of it, shouldn't the doctrine that's there at least try to operate to expose it? And so, yes, we understand sometimes we may be asking it to do more work than it has been traditionally understood to do. But if that's the way the attitudes, and I think this is what Angela said, the attitudes and the stereotypes and the discrimination are working, how can we get at it unless we really begin to, in some ways, say something about groups, which, you know, that's the bulwark we ran into.
Well, I wanted to suggest to Angela, as I heard you talk, it occurred to me that I think there's another racially palatable performance out there. And at one time we called this tokenism, but I think there's a more sophisticated version of it now. In some settings, wouldn't be in all the settings you described, but in some settings where we have relatively sophisticated white liberals in the sense that they've internalized a whole bunch of racial egalitarianism at some level, right? Then I think I would call this contained radicalism. That is, you can have a person of color, especially a black person, but I think it applies to all persons of color, who seems to be pretty radical, who seems to be pretty deviant, who looks a lot like Keisha in some ways, right? As long as she has no real power and you can contain her, then that becomes a racially palatable performance in those settings. And I think it's an important one for places like the places we work.
Just a follow-up, in some way, does that person participate in that and become, in some ways, the spook that's set by the door, or is it a sort of externalized sort of?
I think there's the whole range of reactions to that role. You know, I think there may be some people who internalize, you know, I don't know, this is outside the bounds of my experience, but I guess I'd say there may be some who internalize it. More likely, people. What was the last thing? Is sort of the despairing.
Resigned modeling.
Yeah, right. So, but it's resigned modeling to this particular role of contained radicalism.
With respect to the black-on-black testimony in the sexual harassment context. Of course, this always comes up with women saying either I didn't experience sexual harassment or I didn't find the pornography at work offensive. And the plaintiff's strategy was to bring in Dr. Susan Fisk or someone like Dr. Susan Fisk and talk about the various coping strategies that women who might seem like they weren't harassed or weren't offended, what was so interesting to me was just kind of overlaying your strategies here or your performances here to those coping strategies. And I actually have a very kind of concrete question. Maybe it's really just Devon's question. In some sense, I don't like the idea of the expert coming in and saying there are some people who there are 4 types of people. There are the women who are silent, who make a joke of it. There are the women, I mean, there's something like that. So having it come into the courtroom through an expert seems very useful,
Right.
but something I don't like. Yet, in some way, one ought to say that the employee testimony is simply irrelevant. You know, that the individual who says, I didn't experience, you know, we can see it most clearly, the individual who says, I didn't experience harassment or I didn't find it offensive. Once we really acknowledge that there can be bias against some group of persons other than all the group of persons, then it's irrelevant. And it's interesting to me that now we're replaying this and it's still the thing the judge picks out. So.
Right, no, that's true, and that's built into the framework, right? So even this idea that you have to be treated differently than someone who's within your same group, right? That's built into it, that if someone in your group is treated better than you are, then there was no discrimination. And sort of to answer your question about suspicion, I don't know if I think that the black witness is more suspicious than the white witness, but then I think the question is, if there's a black witness who's claiming